Okay, are we ready? Looks like we're ready, yes. Second. So I'd like to welcome everyone to the March policy meeting. We will start with any announcements from Ashley Kitten.
No announcements tonight.
All right, so moving on, let's go to the minutes. Does the committee want to approve the minutes, move them on to the legislative? Yes, I got you. I got three. Okay. Minutes will move on. And that brings us to old business, second readings.
Did we decide for second readings we just wanted to click through, see, or did we just want to address questions that anybody had? I feel like we took a look at everything, made changes as we were going through. I feel like we're in a pretty good place with all of these. Is there anything outstanding that anybody feels like they need to talk through on any of those?
On 702.1, this is small detail. It says superintendent or designate and
or superintendent's designate.
Yeah, that's what we wanted, right? That's what we've been saying.
Correct.
I didn't find that yet where it is, but this one has the three. Okay, got it. Yeah. Okay. So it's been updated. Okay. So I had that, and then same thing. It was director of finance. So which one was that? Okay. So right. So it said it says director of finance or designate instead of director of finance. But my first question is, do we want to switch that to chief financial officer? Okay.
Yeah, so if I could just comment, and I wonder, Ms. Iannetti, I think it gets really confusing with depending on where you're looking at the policies. So the drafts, if there were any changes in them after they're PDF'd, they're live under policies drafts. So I'm not sure if what you were looking at, because what I'm looking at
was the draft. Okay.
Says 4.1 does say chief financial officer or chief financial officer's designee. So I do think we changed it. It just gets confusing if you're looking at the PDF or the live draft.
Okay. Well, good. So that was what I had for old business. Does anyone else have anything for old business? Jenna? No? You? Mary Beth? No? Okay.
Can I just add one more thing, Ms. Ina?
Yes, go right ahead.
Just so that you know, the ARs. So for these second readings, we had not had the ARs at first reading. The ARs are now here, and we've made changes to reflect the changes in policy, and we actually added, it was a form for the policy on donations and gifts.
And that form is attached there, right? Yeah. Okay. Anyone on the board? Any questions? Oh, go ahead.
Yeah, I only had one because I looked and it looks like the changes we talked about last time were made, which is great. So on policy 702, I think I raised this the last time and I candidly can't remember where we came out. There's a statute cited here and it does have a requirement. I think we talked about this a little bit last time where, we have to keep an accurate account of all devises, bequests, grants, et cetera, basically all the gifts, I guess I'll call them, that we get. And at the end of each fiscal year, we have to render a detailed statement. Now, clearly, this is something that we delegate, right, presumably to Mr. Leckman's office. But it was a question for me whether it's something that we should reference in this policy as an expectation that we have and something that we're formally delegating, just because it is a statutory requirement.
If I remember our conversation, is it the board's responsibility in the way that it was written, right?
It says it shall be the duty of the board.
Yep. Okay.
Yeah.
So we're reflecting that language.
Yeah, it's in the statute that's cited and it's in subsection C.
So is your question, should you be delegating?
Right. Yep.
I wonder if we can based on that language.
So
can write that.
Mr. Diazio did review that piece And I think in the admin content of the agenda, I just have a note there that he reviewed the statute language and felt that it was appropriate in the delegation of responsibility section, adequately covered all of the statute language, and that it should continue to say board.
You okay with that, Jenna? Yeah. Yeah, okay. Okay, anything else under old business? Okay, moving on.
Okay, so if we take a look at new business under our first readings, you'll see, like we talked about last time, that table that has our summaries. So I guess we'll just chunk and go through 002 and 003 are listed with those notes. We talked about looking at contradictory language regarding board approvals, took a look at what our solicitor advised us and aligned that with 006 and created an AR for 003. So if we want to look through those individually or as a whole, I think it was really just making sure that there was consistent language and making sure we're all happy with what that looked like.
Any comments on this one? I mean, this was where it said unanimous vote and then it said 2/3 vote, so our solicitor said 2/3. That was the big change.
Pretty straightforward for those,
Yeah.
right?
Okay, so I think we're okay with those. Not seeing any.
Then 206, with administration recommending changes to language regarding assignments of students to schools. Assignment should be based on the designated attendance area for each school, with exception for placement due to special needs, location of appropriate educational programs. I imagine there's some discussion on this, so maybe we want to pull that one up and go through any questions or comments from anybody based on what we think we captured here.
And I can chime in here. If you recall, this one was really on the agenda last month just for some conversation. So we're bringing it back, and I tried to collect some data to help answer some of the questions maybe that you posed last month. And I had shared with the board the historical data for the last couple of years in terms of the number of what we refer to as a variance request here in the district, which is a family requesting to attend an elementary school that is not the elementary school where their home is located, based upon our drawn attendance areas for the 4 elementary schools. So I've shown you historically since 1920, we've ranged from 17 requests all the way through 46. This year we have 33 of them. And then we tried to break them out for you into what type of request they were or what the reason was. We tried to break it down so that you saw, maybe there was 46 kids, but it really only represented 34 families because there's siblings in the same family for you. Repeat requests, meaning they were approved in 1920, so then they were approved in 2021, like they were, repetitive in that way. And then how many new requests. And the reasons for the requests were, we broke them down so you would understand if it was maybe a family relocation, meaning maybe they moved mid-year within district but to a different elementary school's designation, versus a staff request, or you will notice we indicated it as school preference request is really where the majority of our requests are. And then there's that small, and you'll notice it's a very small population that is the, one of the communities in district that has historically had some choice between 2 of our elementary schools. And then we also gave you the variance movement so that you would see, and I know sometimes that chart is a little hard to understand, but on the left tells you the school, the home school where they reside. And then across the top is the school that they requested to go to. So that, for example, you can see in this current year, you can see that 12 students that reside in Jarretttown are attending Fort Washington based upon their request. That's how you kind of look at where they 2 come together. So I just share that. I'm happy to answer any questions about it or entertain further conversation about what you are thinking with this.
I do want to make a comment. Based on our conversation last month, we did have our solicitor look at our attendance zones, I'm calling them. And they're fine. They meet state and federal code, is that correct?
Yes, he confirmed that it is up to the district to set the lines basically between, what's considered Jarretttown, what's considered Thomas Fitz or any of the other schools. That is a local LEA decision.
Okay, so we take that out. We don't have to worry about that. Okay, some feedback about this?
I was just curious where you said you laid out all the data. Where can we find that?
So I believe that I shared it in your director's briefing, and it might be in
It's
It is
all
in the-
also in administrative
Yes.
content.
administrative content attached to the agenda under this item, yeah. 6.01, if you scroll down to the admin content, you will see the documents attached there. You do have to be logged into Board Docs to see that.
Okay, I see it now. Sorry, I didn't scroll down far enough.
Jenna?
So the category that jumps out to me in the variance request historical data is that school preference, both because, as you said, it's the largest grouping, but also because to me it's the most sort of nebulous, right? Family relocation, I get that, right? You move when your child's in 4th grade and you want them to finish out at whatever school they were at. Makes sense, not a big deal. And, as I said before, certainly if there's some education related reason why they need to be at a different school, to me, that's a no-brainer. But if school preference really means I just would rather go to a different school for some reason, I don't know, I'm a little on the fence about why we're doing that. And again, I'm not expecting to get into student level discussions here. There's probably a lot of student level issues in that group, but that's the area where clearly it's slushy, let's say, right? It's just less clear what's the reason for the preference, because again, we draw the lines and the expectation is that students go to the school that they're assigned to unless there's an extenuating circumstance, in my opinion anyway. So yeah, as we think about how to draft the policy, I want to give flexibility because there are individual circumstances that we're not going to be able to predict necessarily in language, but kind of like it says here in whatever it is now, I guess it's 1.3 maybe. We do expect students to attend their designated school, right? Unless there is an extenuating circumstance. And to me, just saying, I'd rather go to Maple Glen or whatever is not what we're looking to do with that exception process. My 2 cents.
You have interpreted it correctly.
Check, go ahead.
Yeah, in the notes it says, due to special needs and location of appropriate educational programs. Special needs, there is special needs as identified in an IEP, or special needs as, well, I need a babysitter or something like that. And I just think that needs to be quite clear what we mean by special needs.
Correct. Our intention is that it is driven by an IEP. And I will indicate the solicitor has given me a little bit of feedback on language that how we could strengthen this should the board choose to move in this direction. I've just been waiting to see where the board is at, and then we'll certainly clean up and get solicitor advice on the language. But that's what the intention was, that it refers to a student who has an IEP.
Just one small linguistic thing. 3.2 says an existing educational program more suited to his or her special needs. So it just has to be gender inclusive and change that to there.
Absolutely.
Okay, so am I right in gauging that the committee is okay with moving this forward? But the 2 things I'm hearing is, one, well, we need the IEP's language spelled out. And then, I don't know if we said this yet, but what about when this would go into effect? I mean, Jenna sort of hit on it, but we didn't so that would be the other thing, because like we
Jen?
said, we don't want to move kids that are already somewhere.
Jen?
Mark, go ahead.
No, I'm way over here this time. I agree that I wanted to discuss the when. That was one of my two things, because in cases where a family with multiple kids is already in this situation, I wouldn't want to necessarily separate siblings. So I think it needs time to age out, at least for those families. And I'm not sure exactly how we would say that in policy, or whether we'd say that in policy or that goes in AR perhaps. The other thing I think is if a student is moved due to contents of an IEP or whatever wording it is that we eventually place there, do we need to say something about transportation? I mean, the assumption in my mind is if we are agreeing that their best placement is in a building that's not on a regular bus run for them, then we would still provide transportation. But I feel like the board needs to say so. And I wonder whether there are cases where we wouldn't, and I don't have any in mind, but I'm curious about that.
So we would include that in the IEP as well. So special transportation would be noted in the IEP if the student is going to a school that's not considered their neighborhood school. So just to note that that would be placed in the IEP should the student go to a different school.
So that sounds like it would be adequate to not mention transportation here, since presumably we're going to be following the IEP in every way. So maybe that's not necessary here, unless there are cases, and I'm just asking, might there be cases where in some cases we provide transportation and in other cases we don't? And that may not be driven by IEP, could be driven by something else. Like, for example, if we're sort of grandfathering certain families into this or something like that, we may need to say something about how transportation works.
I think the current practice, if I have it correct, and I can certainly verify this, is when it is a parental request in the way that we've been doing it now, let's say for a school preference, we have not provided transportation, the family has to transport. Certainly if we decide to implement this, I would agree with you, Mr. Sirota, that if we are making those decisions, we're providing the transportation. And if we're no longer approving, something for a school preference type thing, then we wouldn't have a transportation issue. As far as grandfathering would be the term I would use, I would work with Mr. Diazio to come up with what that language would look like. I certainly would not recommend to the board that we tell families you now have to move back to a different school building, that we have some sort of structure to allow those that have already been approved to continue in that manner.
I do believe there's language in there that says when it's a parental request, it's only when there's room in the building you're going to.
That's in the language that's being struck.
So that is all gone. So if we make an exception, so Jenna had touched on this, and there are things that we might not foresee that we would approve in some manner.
As drafted, there actually isn't an opportunity for that anymore. If we want to carve out that possibility, I think we would have to carve it out in language, but I don't see it here anymore.
So if I could point out back
Other
to
than the
policy 003, we added to policy 003 a form called exception to board policy. So should a family read this policy and be like, but I still want to request it, they could fill out that form and they would submit that to me. I would review and make a recommendation to the board. It would have to be placed on a board agenda for me to say I am recommending an exception to board policy 206 due to blah, blah, blah. And then you would then be the ones to approve or not approve that board exception. So there's something in place that if a family really wanted to, again, would come through me to you.
Mark?
I don't love that in this particular case. I mean, I like the idea, the concept, but in that particular case, I don't really like it because I don't think the board should be making decisions about individual That's not a board. It's not normally a board function. We're much bigger picture than looking at individual situations, and I don't want to necessarily drive us towards starting to adjudicate individual decisions like that. I'd rather delegate that, frankly. I know, and that may be what you're pushing back against, but I think that's the discussion we have to have, is where is that line?
I'll be honest, I'm not necessarily pushing back against that if you change the language of the policy, because I will follow policy. And I would not be recommending to you if a family just wants for their own preference, I would not recommend that to you. I wouldn't bring it to the board for approval.
Go ahead.
A big chunk of it is staff. Like, will there be blowback about that? Is that perceived as a benefit that staff can have kids in the building where parents are? And then, should that be phased in? And then, are we talking about eliminating the moving mid-year and being able to stay where you are? And is that written into the policy as well?
So
And
to
then the
okay.
IEP one, that last one, it sounds like the parents could make a case for that it's not just decided by the IEP team. Like the parent could say, my kid has special needs and needs to go to a different building, not that it's a documented special need.
That's a word, like wording. We can definitely fix that one.
So to answer those, the staff thoughts, I have not spoken with staff yet. I would certainly, again, grandfather those same ones. I'm not going to tell again, same thing, if they're already in that process. However, moving forward, I would not be inclined, and if we write the language the way that it's being proposed, to approve a staff request. They work in one building, their child attends another. I would not be inclined to move that forward or approve that, but I would grandfather those in that are already in that particular process. That would be my recommendation to you. And as far as moves, I do think the policy, I think it would allow for, I started the year at Fort Washington, but now I've moved and I'm in Maple Glen. I do think that's a legitimate reason to let them finish out that year. I think it comes to some of these school preference requests, though, are that move happened in second grade and they want to finish their entire elementary career in the building that they started second grade. And then their 3-year-old, they also want to do that. And I do think that's a practice that for the year that they are in, that we would allow that. But I don't think we want to get in the habit of allowing it for multiple years after that.
Would that be through your approval process or whatever approval process is established, or would that be written into the policy?
I think we could do either way. And I'd have to look at the ARs. I feel like the AR does address that. So once we understand the board's direction on policy, we can then update the ARs and bring them back. This is one that I anticipate is going to stay here at first reading for yet another month because we just need some direction from you and then we'll get the language right.
Yeah, presently it's in the AR about those situations, mid-year situations. So.
My interpretation is that a lot hinges on 3.2 right now in terms of there being discretion or not. And if the direction here is we change the language back to something that was crossed out, honestly, of a student with an IEP may be assigned to a school, that's very different from the way it currently reads. And if that's the proposal, then I think the discretionary area is, it at least isn't reflected in the policy. It's clearer. I don't know if that's something that we want or not. And it seems like that's the question we're discussing is do we want there to be, like the way I read 3.2, it looks like there is some discretion there about, for instance, making a case about an existing educational program or what constitutes a student's special needs. So I would want to hear from other board members and you, Dr. Smith, of just like how you read that.
My intention is for that to read that the changes to the school that the child attends would be based upon their IEP only. And back to Dr. Thomas's point, a parent through the IEP process has input into the program, and then through our student services department, well, where does that program exist? For example, there might only be an autistic support program in one of the elementary schools, and through the IEP process, if they determine that they need autistic support, then the child would go to that school. So the parent does have input into that, but through the IEP process. So I would intend that language clearly needs to be changed, but that's the intention of that.
Anna, then teacher.
Yeah, that makes sense to me to kind of put some guardrails around it because we have a process to address educational needs, which is the IEP process. So that works, assuming it all works the way it's supposed to, then that should address any needs. So I think that's kind of an elegant way to the discretion is there through the existing process, but it takes away, you know, the kind of more nebulous requests. Because again, if there really is a need, we would reflect that in the IEP. So I like that. Again, I think it's an elegant solution. There is something else that's in the AR that I question whether we should bring into actual policy, which is, again, well, I guess it depends. If we're limiting the, you know, instances where this can be exercised, maybe we don't need it as much. But if there is still some squishiness, technical term, about it, there's language in the AR that talks about, you know, if we are granting exceptions that aren't IEP based, because again, as I've said many times, that should always trump no matter what, totally. But if it's a more kind of discretionary exception, if there's room for that still, I do think, and I'm leaning towards suggesting that there should be language in the actual policy that under no circumstance can kind of one of those more discretionary requests result in a need for us to add staff. You know, now we're over the classroom size because that affects the whole community, right? So now the whole community has to pay for an additional teacher because now we're one student over in this building because, you know, somebody wants, you know, their child to, you know, finish their last year at whatever school. So I think that's kind of a tall order to ask that, you know, we actually are incurring financial obligations to accommodate any of those non-education based requests. So that to me feels more like a policy directive that could be pulled out of the AR.
Jeff?
But Jenna, that's only if we keep discretion in the policy, right? Right, okay. I'm with you on that. Because, I mean, it seems to me that the crucial decision here, and there's two of them, is discretion or not, which then flows into Mark's point about, from Dr. Smith's point, of if there can be an exception at the board level. And that's sort of, it flows from that discretion because the discretion's with us. And Mark, I hear your point that we typically don't get involved and maybe shouldn't get involved in sort of individual situations, but conceptually, isn't that why an exception to a board policy may exist? I mean, it could exist for a group of students or a group of families, but it also could exist for one. And the way I'm looking at it through the amendment or proposed amendment to Board Operating 3 and the new AR under it, the superintendent is kind of like the gatekeeper. I mean, it comes to us with a recommendation or a not recommendation, which I guess ultimately, and especially with the language in there that the individual would be allowed to address the board with regard to the exception at the meeting, we could not follow the superintendent's recommendation. But I think that things ranging from the reason to budgetary reasons to whatever, I don't want to say they get filtered out, but they at least get viewed through the superintendent's lens before it gets to us. So I appreciate the concern about individualized issues, but right now I think I lean toward that over discretion in this policy. That's just kind of where my head is at the moment.
I want you to respond, but Teacher, I did skip her already. Did you have something? Okay, all right, let Mark go.
I think I agree with you. I mean, I agree that discretion is a slippery slope in the policy. And so it seems a lot cleaner to eliminate it and then have an exception process. And while my objection to the exception process in the specific case is really specifically about this because it's an individual issue, it's not like, I think the exception process makes good sense. I think what you're saying is a reasonable compromise. One addendum I would do is you said that the exception process comes with a recommendation from the superintendent to approve or not approve. That's not explicit the way I read it. And if we made that more explicit, that there is explicitly a recommendation from the superintendent, maybe it's right on the form, you know, there's a board decision line, but there's no superintendent's recommendation line, for example. Maybe that's a place to do it. Maybe that's a reasonable compromise.
I think I drew that from the proposed AR. So, you know, maybe it should be in policy? Or maybe if we're going to go all the way down this route, should there be a cross-reference in this policy to say that absent falling under 3.2, the board's exception process, including the recommendation of the superintendent, applies? Maybe that gets too complicated. Maybe it's not necessary, but Dr. Smith, what do you think?
I will just, maybe I can give you an example of how I've seen this exception used. A family moved out of district, to Europe, and it was April, and they wanted to finish the year in our virtual school. There's no policy that says that they could do that, so they completed this form, came to the superintendent, seemed reasonable. It wasn't a huge, expense to the district, and so form was filled out, superintendent made the recommendation to approve it, and it was added to a board agenda, and the board took action. Everything is redacted from, so if you're concerned about knowing about an individual student, the name and the specifics of the situation are redacted from the form when you see it. While it does say that the family can address the board, that is at their discretion if they choose to make themselves known and come to the podium and speak at that time. Other than that, it would be completely really anonymous. You would not know who it is or what this, the detailed circumstances are, but you would see the recommendation of the superintendent.
Yeah, I do see in the AR where it does specify that the superintendent will recommend action, and then it says the board will consider the superintendent's recommendation. Certainly implies that there's an explicit recommendation from the superintendent. But it is only an implication. I would rather just strengthen that, but otherwise I think I'm good.
Okay, and I have a question along this line too. Go ahead, Jeff.
I just want to say, Dr. Smith, to your point about anonymity, I wonder if assuming we go down this path, I wonder if the AR to 206 should have something about families can request an exception anonymously, just so people know that if they do go down this path for a reason, it doesn't need to be aired at a meeting like this unless they so choose, something like that somewhere.
We can certainly figure out some language for that.
Along this same line, could a family skip over the superintendent and come to us, or say you don't recommend it? It's going to come from you no matter what. They can't skip you in the step and go to the board.
That has been the practice that I'm most familiar with, is that it has to go through the superintendent.
Okay. Good.
Would it make sense if there's an approval process for that to happen in executive committee rather than?
I'm not sure that it's an approved topic for an executive session discussion. I think it would need to be at the public meeting.
Teacher, you've been so patient.
Sure, that's my treat. 2 questions. Number 1, if there is a family who has one child with an IEP and gets moved to another school, right? What about siblings? Would that require a exception request? Should the family want that?
I will share my experience, and maybe Mrs. Summers might have different experience. In my experience, the special education student, it would be placed in the school where the program is. Their siblings still attend their school of residence, and we provide transportation for both of them. So it's really not much of a difference for a family, but I certainly.
Yeah, that's been the same process that I've been used to as well.
No, I just wanted that clarification. The other question I have, and again, this may be a technical language issue where sometimes I struggle. 1.3 mentions no illegal discrimination. Is there anything, to me, it should be no discrimination, right?
I agree. I think that Mr. Diazio really will probably suggest some language changes to this policy. Yeah, I would agree.
Okay, I'm glad that I wasn't missing something here. All right, thank you.
So what happens to the area that's not zoned? Or is that area zoned? What happens there?
So that is another question for the board to really to tackle. We do have a map of the lines. Clearly, there's delineated lines for all of the areas. There is one small community that historically has been given choice. And as we tried to investigate, and I believe somebody with some historical reference here was able to share with us that apparently when Maple Glen was built and there was redistricting to make the 4 schools, transportation issues were certainly considered, and that one community was given choice to be honest, I guess, as an attempt to desegregate and to allow that community to have choice and diversity in both of those schools. That's what has been shared with me. I don't know the validity of that. I certainly trust the source, but I don't know if times are different. You can see it's a very small number each year that has been requesting that, at least for the years where we've been tracking it. I would defer to the board if that's something you want to allow to continue there, or you just want to set the hard line that, this side goes to Thomas Fitz and this side goes to Jarretttown.
Comments? Oh, you will go, okay.
Yeah, so, and I think it is important for us to try to understand what that historical reason is, because it strikes me as odd, I'll freely admit. And especially if that's what it harkens back to. It's been a minute since Maple Glen was built. So yeah, I mean, my personal view is, unless there's something more going on, right? Something, some other reason that we're not aware of, my preference would be to just draw the line. And of course, people who are already, we've talked about it, right? Grandfathering, I get it. But I don't know why we would continue to entertain that for new families. I mean, I feel like the line is the line. Again, could be handled on an exception basis if there's some reason. But I'm just not totally getting why we have this kind of gray zone where you can go to either school. It's an odd thing. And I'm guessing it's just one of those things that kind of carried on and on and on. And now may be the time to say, all right.
And it's not a large number.
Yeah. Yeah. So again, I'm fine with grandfathering, all that good stuff, but I would just draw it and be done.
Yeah. Committee?
Maybe a focus group or something along those lines. Like that would be a big change and people value choice. So, making sure that would be well received, or it's not, dishonoring the spirit of some gentleman's agreement that was made when it happened. Or if we're just going to move on, I don't know. I don't have an opinion, but I would want to be sensitive and, just hear what people have to say and what they think about it.
I would certainly, on behalf of the district, be happy to reach out to some members of that community and just listen and learn a little bit and summarize and bring that back to you. I did just this past week, I was over at the after school program and attended there and learned a little bit. So I certainly asked for some names of people in the community that I could connect with. So I'm happy to do that and at least give you some information. I would say that personally, I tend to agree with Ms. Evans that maybe it is time to identify that, and it is such a small group at this point.
Stu?
Quickly, from a policy standpoint, I think if this is the policy that we've written, I think it follows that there wouldn't be anything in this policy to accommodate, a choice zone from the past. Now, that said, I think the sensitivity around honoring families that have already begun in the school, I think, is the key there. But I would say that if we're following the policy the way it's written, then we draw the lines.
Check, go ahead.
Does the policy also then require attached the map? Because I don't see that. I mean, that's not really added to it. And I think last meeting there was the discussion, well, what if, or about, hey, if I buy a house somewhere and things change. I mean, I do think that it also needs to be clear that at some point these lines may need to change, right? And if those lines change, that is something that I think we need to account for as well. And I don't know if that's clear enough in this current situation, because we don't know, I mean, there's policies in place, but should you then also have that reference to the lines and make a note that these lines can change after board approval? And that may be a whole separate issue, and maybe it's somewhere else in the code, I don't know.
I believe if the board wants to change the attendance areas as they are currently designated, it would require board action. And I imagine quite a bit of community input would occur regarding that. It's usually something that superintendents don't like to have happen during their tenure, but it can. But I do believe that 1.3, I guess, is the one, that it is up to the board to determine the school attendance areas. We could attach a map. I'd need to work probably with transportation to have a little bit of a night, like the one right now that I have has hand-drawn lines on it, but transportation and the registrar know, like, specifically down to the address. They look on the larger, map to see where students should attend.
Yeah, because I think having that as a reference to the policy will be very helpful to families, should they have questions about it.
Jeff?
I'm okay with it being a reference. I just think we want to be careful that the map is not considered the policy. It might take some legal wording how we do it, because as I read this, as Dr. Smith said, we determine it, but yet, in theory at least, under 3.1, on a recommendation or a review by the superintendent and then a recommendation, it could change. So I think we want to be careful that no one could read this policy and say that the current lines are etched in stone, even though, and recognizing that the possibility of change is likely remote. But as the policy says, if it was necessary for the effectiveness of the instructional program and Dr. Smith decided to do that, which doesn't sound like she's of the inkling, it could in theory.
Yeah, I think I was more thinking of the practicality of this. I mean, this is something that's written for the board, but it's also written for the community. And I mean, when I was reading this, I was like, well, where are exactly the lines? And it took a little digging, frankly, to find that. So that's really where I'm coming from.
Okay. Mark.
Oh, I'll just add here that I'm on the side of Mary Beth with how do we obtain more information as to why and how it operates. And I also think if it's not broken, it's not affecting the district in any way, then why change it for the sake of changing it? I would lean on the side of caution of, if something was established because of X, let's really understand the why behind why it was established, and then really determine if it's something that we need to change. If it's not affecting the amount of staff that we have to bring into the district, it's a small community that, from what I'm hearing, doesn't elect that choice often. I don't see the sake of changing it just to change it without anything actually affecting our school district at all. So I would want a little bit more information, really understand the why behind it, the historical aspect of it, and then some data as to how many families are electing, who's not electing, and over the course of 20 years, how many families have elected, and if there is any financial impact to the district because of that election.
I will certainly, and I know somebody has indicated they can help connect me with some people. I will try to find that out before the next policy committee meeting so that you can revisit that particular group. I will be honest though, and upfront, I'm not sure that that we kept records historically of how many maybe exceptions were asked, beyond the 5 years that I have for you. And you can see it's actually the last 3 that I have a lot more level of detail. We don't have that information tracked in that way. But I'll see what sentiment I can get from community members and be able to share that back.
And along those lines, if we didn't fix that one area, how does that, from the solicitor's point of view, how does it affect when, say, people apply to, can they use that as a reason?
I'm
Like, there's a
curious,
precedent to put a kid somewhere that's not educational. That's a question for Ed, I guess.
on the chart that you provided, are those exceptions other than the 2 schools that they're allowed to pick?
Are you referencing where it says the zone with the reason to request the 1, 2, and 2 in the
Yeah.
last 3 years?
Yeah.
And are they requesting to go to Fort Washington or Maple Glen?
Right.
I would have to dig down into that. I think it's just between Thomas Fitz and Jarretttown, but I can dig down. That I should be able to tell you.
My hunch is that's a variance from either Jarretttown or Thomas Fitz. Those are kids that don't want to go to those 2, because I feel like there's a good amount of kids that go to both.
I can find that level of detail for those 5 kids, yeah.
So it might be a bigger impact than what we think.
So I'm hearing, if I've got this right, work with the solicitor on the language to the thought of exceptions only based upon their IEP, and then get some information for this small community to understand some more of the history, bring that back, and maybe we can even revise the AR to reflect, if we move in this direction, what that would look like, and we'll bring it back to first reading next month. Okay. Thank you very much for the conversation, very helpful.
And just add one little thing in there that I didn't bring
Just
up.
when we
It
thought
really
we
is
were done.
No, it's a little thing. Could a GIEP also be, include that kind of thing? And you have to answer it now, but.
Well, we do have those services in all 4 of those elementary schools, so
We do right now.
We do right now. Hopefully that'll continue. But yeah, so but we can be more specific about that as well.
I would include a 504 plan too.
Okay.
Yeah.
So 504 is a little bit different because we're looking at accommodations. IEP, GIEP, we're looking at specific direct instruction that a teacher has to provide. So 504 is accommodations, it's access to education, and we should be doing that in all of our schools.
Sometimes it can be the physical environment that might be an accessibility issue that doesn't require an IEP.
So we could look, hopefully we're all ADA compliant, but that is something that we absolutely could be a discussion as part of the 504 discussion, yes.
Okay. All right. Moving on.
Let's talk about 216. Okay, so reviewed by our district solicitor, there were no substantive changes recommended for this one, but some noted revisions are in formatting and arrangement of our content. And then in our AR, again, just more reformatting for ease of read. So any thoughts, concerns, comments on this one?
Anyone? Jenna, are you getting something out?
Not on this one.
Okay. I think we're good on this one.
Okay. The next is 907, visitors to school. So this isn't volunteers, just visitors to our school, reviewed by our solicitor, recommended some additional language regarding our health and safety and welfare, as well as the prohibition of any type of recording devices. So any thoughts or comments on this one?
Go ahead, Jenna.
Yeah, so it's actually on that recording devices section that I had a question, because it, and I certainly understand the reason for having that rule. But then it says, exceptions, and I guess we probably need to number these because I don't know how to designate which paragraph, but it's the one I'm looking at the paragraph that says no visitor. Yeah. Oh, it's up there. Okay. Okay, cool. All right, sorry. My version, it's not. My bad. Okay, so the sentence that says exceptions may be made for special student events such as concerts, field days. So I'm just clearly when we have a concert, every parent's recording, we all are. So I don't want to be in violation of this policy and have people say, Ms. Evans was recording her kid, I'm gonna. So I'm just trying to figure out how do we reconcile that exceptions may be made, because is the expectation then, we just talked about exceptions to board policy, right? Is the expectation that I have to, clearly not, but that I have to fill out a waiver to record my kid at their concert?
It's
So I don't
the
know if that-
Evans exception.
Yeah, the Evans exception, because I'm going to record. So I just, that language just stuck out to me a little bit, because I don't want you to get inundated with, silly requests that I know we're going to grant that people can record.
Do you want it to say shall be made, or you need a
Yeah,
whole
like,
big wordsmithing thing?
Yeah, I mean, clearly when there's, and I don't know how to kind of categorize those events, but the concert was the really easy one, right? But I also get at the same time, we don't want parents coming in if they're, assisting with some class thing and, filming, because, so I'm just raising, I feel like that exception language might need a little bit of tweaking, just so that it's clear that of course you can come and take pictures of your kid at the spring concert and, yeah, I don't want my name all over Facebook that I was violating board policy. So thank you.
You think the word will or shall would do better there?
Shall?
I think
Oh, Jeff?
there's a broader thing that covers this, which is the First Amendment to the United States Constitution, which basically says that if you're in a public place with permission to be there, anything you can see can be recorded. And it doesn't say it in those words, obviously, but that's basically how it works. So if in a publicly open concert, you can record. There are some limited exceptions and ways to, like, you can make laws that probably can't be enforced around that prevent it. Like, you'll see signs around bridges after 9/11 that says no photographing this bridge, which, will never be enforced, but people do it anyway. So, make those laws anyway. We can make a rule around it, but I think you really can't prevent recording at a public event.
Is it okay, go ahead.
Unless it's prohibited by another law, such as copyright, because for instance, you
Right.
can't tape Footloose. People might do it, but Ms. Guareni's going to tell us in the beginning, we can't do that.
So technically what that rule is, you can record it, you just can't do anything with the recording.
Correct. I think that's right, Mark. Yeah.
Yeah.
But, and that's why the shall worries me a little bit. What I'm wondering is if in the policy, it says without the express prior approval of the superintendent, building principal, or their designees, could there just be something in maybe the AR that for, concerts and field days, the building principals will just say it's okay? I don't know. Maybe that's too easy a way out, but it was just a mindset of mine.
It's a little tricky with you're right, with the plays. Stu? Oh, no, I'm sorry. John?
That's okay, I'm still new here. Well, before Jeff was sharing some of the thoughts on how that might work, sort of a blanket exception, I was wondering, is it as simple as changing the word to exceptions include special events such as concerts, field days, and similar events?
I can certainly ask Mr. Diazio too. I can share with him what the thought of the board is, and is there different language to put there?
When I read this, I thought of let's say someone's coming in to present to the school at an, what do they call those things? Assembly, thank you. And they want to record themselves at the assembly for their own publicity and data. That would need approval and superintendent. I didn't think of it as someone in the audience, but a visitor to the school, not a parent or community member. That's how I read it, and thought that that would need approval.
That's actually a really good point, because how we're defining visitors and creating the mechanism for them to come into schools and check IDs, that's not happening at after school events. That's happening during the school day for school visiting purposes. So that's a really good point.
Sure.
Yeah, and on that same sort of thing, I was looking for the definition of visitor in this one because there will be instances where there are visitors who make a video of a lesson. And for instructional purposes, probably for training purposes within the district or outside the district. That is a different category that I think you're trying to address. So I just don't know where the.
Those would be volunteers or contractors.
Okay.
A visitor won't be in a classroom. A visitor won't be, like, there is a big distinction between.
So is that going
those.
to be?
But let's define that.
Defined, yes, exactly, because that is, I think, very important in this context.
We can add a definition.
Jenna?
Okay, so let me give you another scenario. Because, you know, I don't want parents to stress out that they're violating board policy, you know. So, you know, we have parents come in for class parties, right? They inevitably take pictures of their kids, as I do, right, at the party. Is that prohibited by this policy? The way it's worded? Arguably, yes. And if that's what we're looking to do, we can talk about that, but I just want to be clear, that's happening every party.
Those are also volunteers,
So that's
not visitors.
Well, no, they're not. When I go to a class party, I just went to the Valentine's Day party. I'm not a room mom. I just went am I really a volunteer in that scenario?
Yes, you are
Okay.
a cleared volunteer in the district.
I am, but I don't know, was I operating in that capacity?
Yes,
I
you
don't
were.
know. So, okay, all right. So the distinction then is you're saying, my class party example, you're a volunteer, so that's allowed. You're not a visitor.
Isn't there the case where students can opt out of ever having their photograph presented?
Yes, there is.
So wouldn't that have to apply? Like, even if you're a volunteer coming into, a class parent coming in to facilitate a party, they can't take pictures and, well, I think they can take the pictures, but they can't post them, right? I mean, so does that have to be covered here? And they're basically recording. They're just, it's a question of there's a separation between the recording and the publishing. This only talks about trying to just prohibit recording. And I know, again, we're talking about visitors in this particular paragraph, but.
It gets a little tricky because no one, except for maybe one or two people in the building, know who those kids are.
Right,
So
so-
you can't even,
So here, I'll tell you, so Cat in the Hat visited some classrooms and we got lots of pictures with kids. The teachers are very aware of this. And so that some of them sent pictures to us afterwards and said, here's some pictures, please know that this child is not allowed to be in publications. Or they might say, Lori's not allowed to be, but her back is turned, or it's her head, or you can't discern who it is. So the teachers are, particularly at an elementary level, are on top of this and usually will let somebody know, you can't post those pictures. I don't know, Ms. Kitten, if there's anything you want to add.
That's exactly what I was going to say. Teachers are very, very aware.
okay. And one thing I noticed in this policy is that the photo ID, is that enough to,
So we have a system called Raptor in all of our buildings. All of our front office staff have access to Raptor as well as our administrators. We can enter in information from any photo ID with that personal information. We prefer government ID because it's easier to run, honestly, than keying everything in. But we can definitely take a look at some internal practices to match whatever this language ends up being. But we can check that database without a driver's license or a
Okay.
state issued ID.
Mark?
The photo ID thing was on my list to bring up here too. I think this is too specific for policy. That can be perhaps AR. Visitors will have to go through the standard security protocol established by the building or, the district or however you want to phrase that. But I don't think we should be specific that it's photo ID and run through a school security system. That's not policy language.
concern that maybe can be addressed that I have with this policy is, say there's a class party and there's somebody who's there all the time, followed by someone who's hardly ever there. Are they both treated the same as they walk in? Because we want everybody to feel welcome. Do you know, so I think that's what this policy is. Like, they're not just gonna waive this, you know, the super volunteer who's there all the time does not get
Have
waived
you
in.
met our office staff? They are very responsible and respect the processes and procedures. Everybody is put through that Raptor system and given that badge. And any problem issue is flagged and I get a phone call.
Okay. The other thing about somewhere in this policy, it says open to the public. Right,
In the recording paragraph, yeah, 3.6.
so it says something like, only if it's open to the public.
Visitors may not attend school events that are not open to the public at large.
So, okay, so the Valentine's Day party, that's not a visitor, that's a
Volunteer.
volunteer, okay. So that solves that problem, right?
I feel like they do make a distinction at those parties that some people are, not everybody has clearances for party situations.
If you ever hear that, please tell me who that is so that I can follow up immediately. Thank you.
Is
Because that should not be happening.
Right, and is that when the whole school, like, sometimes there's just one class doing this special thing, which is different than when the whole school's doing Valentine's Day, just for practical reasons.
They'll limit the number, but certain people are volunteers and other people are just parent guests.
I think to Ms. Kitten's point, I have volunteer clearances, you have to have volunteer clearances. So I think both can, so to your point, everybody should have a volunteer clearance who's attending. But to Dr. Thomas's point, sometimes again, did I consider myself a quote unquote volunteer when I went? Maybe not, but that's just what we are. Like regardless of whether you actually went to help with the party or just to be there and, hey, I guess technically we're volunteers at the end of the day.
But I will tell you, on those party days, our office is inundated with people being turned away from buildings saying, I wasn't on the approved list, I have to come over here. I mean, we have a line out the door with, I have my clearances here on my phone, can you get me approved so I can go over to the Halloween parade or go over to the Valentine's Day party or whatever that thing is. So whether or not they're considered to be a volunteer or not, they are on a cleared list. And if anybody hears there is an issue, please, please tell me.
Yeah.
Yeah, I'm sorry I'm complicating this so much, but this is a lot of new language. So are you a visitor if you are attending, again, let's use the concert. You're a visitor in that situation? After school concert?
No.
No, okay.
You're just attending a concert.
Okay. So this is really meant to address during the school day. Is that maybe the simplified way to say it? It's somebody who is in the building during the school day.
I guess what I would like to do is take some of your concerns back to Mr. Diazio and ask him if he would recommend some additional language possibly there. How can we clarify this to be really clear? And maybe we keep this one at first reading and we don't send it to the board level. We'll bring it back next month if the group is agreeable to that.
Committee, okay with that?
Sure.
Okay. So knowing that it's coming back to policy, are we okay moving to the next? Okay.
907.1 classroom observations. So again, reviewed by us, our solicitor, recommendation for elaboration on the purpose and removal of language that more appropriately belongs in our AR. So we'll be adding that language in there. Thoughts, questions, comments?
I have for 907. Okay, so I just need some clarity here. Is this just for parents or guardians and not for if you were having like a private professional say you were getting a 504 for your student or speech therapy. Are they in this policy? Is this just for parents and guardians? You know, there's someone who might come in to observe your child that's not an employee.
So I believe there was one part in the policy that talks about like a professional, like up to like one in the AR. I think it's in there. The AR notes that who can
Yeah,
come
it's
in.
in the first line of the AR, it says a parent
There it is,
slash
yeah.
guardian or a person with appropriate professional expertise designated by the parent or guardian. But then it sort of reads a little odd about their child. So that's, I mean, the language in that first paragraph may be a little bit odd in the AR. But
So my understanding that this, when maybe we can clarify that a little bit more, that this would also pertain to maybe a behavior specialist that's coming in to take a look at a child and wants to do an observation. So this would be a part of that because it talks about, but maybe we need to delineate a little bit more the difference between when that professional is in, what that looks like during their time within the building.
Okay. Anyone else? Anything else on this? Okay, so we'll move that forward to the legislative. It'll come back, still come back for a second reading, but just with a little bit of wording around private professionals.
So our next section, as we discussed at our previous, maybe 2 policy committee meetings ago, we're going to start looking at our policy news network, our PNN, to see what kind of legal revisions are required or recommended in these areas. So we'll go through some of these policies, first being 137, homeschool education. Again, reviewed, language added to address amendments made. So thoughts, comments, anything that either Mrs. Summers or Dr. Smith wants to add before?
All I'll add is that because of the recommendation of point 1, point 2, and point 3, you'll see some language leaving this policy. It actually becomes smaller because specifics are addressed elsewhere. And for those of you that don't know what we mean when we say policy news network, when you are in board docs, right down here, it says school district PNN. These come from PSBA and they're based upon changes to school code or legislation things. And then they tell you what policies are prompted to be looked at. So this was one, I forget, maybe a year ago that had been brought up. And so we're bringing forth to you those changes today. And you will notice these are not numbered. So this is the first month, I should have pointed that out, that Mr. Diazio, we had talked about that change through the briefing, is starting to review the policies from the legal lens prior to bringing them to first reading here at the committee. And so as he was doing that, he found it quite cumbersome with the numbering. I will be honest, on our end, it's quite cumbersome. I understand from your end, it's easier to be 3.4.2.1 has the, this is the line that I'm in. I do wonder if we begin to clean up our policies, if it will be easier to reference, the second paragraph is where I'm talking about. I wonder if we need the numbers. We are certainly happy to put them back in. We just didn't do that on these yet because there were quite a bit of changes that he was recommending, a lot of them again formatting, but if you want the numbers, we'll add them in. But
I will
would love
say
a
that
conversation.
we started that when there was 3 lawyers and me on the committee.
I mean, we could bring back Romanettes and I would be really happy. Just saying.
We literally, it was 4 people on the committee and 3 of them were lawyers. So that's how we got to that.
I still like the numbers.
It was a lot of discussion and then hard to kind of figure out where everybody was. And we got tired of saying Romanettes. And so then we moved on to 3.1.2.1. Jenna, she's the only lawyer left. What do you think?
So I'm also kind of partial to the numbering. I'm sorry, because it really does help facilitate this discussion. And I sort of view these, they're like mini statutes, right? They're like our little statutes, and statutes are always numbered. And I can tell you the policies at my company have numbered paragraphs. It's just, I don't know. I think this discussion would be really difficult without something to say. I'm looking at this section instead of the paragraph that starts with, so.
Yeah, it was
I'm
really
sorry.
more for the discussion. Is why we started doing it, because just to keep track. I will say I'm partial to the numbering, but I'm not the one that has to do the numbering. So if there's another reasonable solution other than
There's always
searching
Romanettes.
Romanettes.
We will continue to do whatever the board wants. It is another step, but of course we'll continue to do that if it makes it easier on the board when we're discussing them.
And we'll keep our minds open for
Okay.
a better solution. Stu and Mary Beth, you okay with that? Okay. Okay. So this policy, I think we're okay moving it forward. Oh, you have one, okay.
Yeah, and maybe this is just terminology. So, well, sorry, I had one. Let me do the easy one first. So under guidelines, the director of student services, I feel like that should be under delegation of responsibility, maybe, as opposed to a guideline. Not a huge deal, but and then my terminology question is, so right under that, the district permits the enrollment of home education students. Is that the right terminology? Are they technically quote unquote enrolled even though they're not attending district schools? Because when I think of a home education student, I don't think of them as quote unquote enrolled. I think what we're trying to address here, especially as we go through the rest of the like kind of new policies, is we're really addressing their ability to participate in other, district related, events and activities and that sort of stuff.
So, I mean, when we have a home education student, there's information that we have to gather from them. I wouldn't say it's the actual registration process. We don't go through all of that. Now, with this new Act 55 guidance, we are going to be doing more of that because we need that information in our system because the students are going to be within our buildings and we need that information, especially for an emergency. I think that could be language. I could go back and forth with that. I think that it is not the typical enrollment that we are used to doing, but there are things that we do require, from home education families from when they're, coming into, letting us know that that's going to be what their children will be doing for the school year.
And in one of these policies, they can take, say, a band class if they're so in that sense, they would be enrolled in the band class. Yeah. Okay. Anything else on 137? Go on to 137.1.
137.1, this is the first of the new policy recommendations, language on posting of information regarding extracurricular activities. So any thoughts, comments?
Anyone? No? Okay.
137.2, co-curricular participation by homeschool students. Again, new policy recommendation under 137. Thoughts, questions?
Okay, let me
If I could just add to this, just this afternoon, we finalized and added this section right here, special education. This was a recommendation from Mrs. Summers, and we had both Sweet Stevens solicitor or counsel, as well as Mr. Diazio, conferred on that language to be able to add that piece to what does it look like when a special education student who's a home education student wants to participate in one quarter of their coursework. So that was some language just to help clarify that. I don't know if you want to add anything, Mrs. Summers.
Yeah, I just wanted to be, because when you look at the policy, it talks about classes, academic classes, but maybe a student that is getting a home education program that has an intellectual disability that wants to come in and maybe are working on, skills to be independent. So it's not exactly academic, but it's skills that they need in order to access their education. So we wanted to make sure that that was specific within the policy, and that can be an option for families.
Jeff?
This one confused me a little, and it's either the distinction or the blurring of co-curricular activities and academic courses, which this policy addresses both. And here's the source of my confusion. Or maybe it's just questions that need to be answered. So a co-curricular activity merges an extracurricular with an academic course. So they use the example of band or orchestra. That, as I read this policy, is different than just a solely or purely academic course, which is then addressed in the academic courses part of the policy. It's on page 2, under number 6 there. And so I think I get that, but then it says that home education students are eligible to enroll in academic courses and may participate in academic courses equaling up to 1/4 of the school day for full-time district students. So does that include co-curricular courses then also, since a co-curricular course by definition has to have an academic course? And if so, does that 1/4 it create a number that's either too low or too high? Does that make any sense the way I'm phrasing that question?
Sort of. I don't know if I got it right, Mr. Wallach. So my recommendation here would be that we, in the AR, because we had this request at my past district, and we needed to create an AR to identify what are the hours in the academic day by level and what is 1/4 of that designated at. So in my past district, we were able to define that's 2 periods that a student was able to come into school. I think the 1/4 is the part of the school day that a non-home education student that was attending our school. So it's just the actual what's designated as a school day. So like band has an after-school piece that doesn't count into the quarter. It's the quarter of the actual school day, but there might be a band course that makes it a co-curricular because there's a graded component to it.
But if the band course equates to 1/4 of the day, that reaches the maximum, even though it's through a co-curricular
Yes.
activity.
Yes.
Okay, that was my confusion. Okay.
Yeah.
Okay. Any more questions on this one? All right, next one.
137.3, CTE participation by homeschool students. Again, another new policy to break out from that overarching. Thoughts, questions? Career technical education, sorry, CTE.
So, yeah, I have a question on this one. We do send some students to Northern Monco, I believe, for the life skills class. So this policy just says Eastern, but we could be in a position where we send kids, do they call it Northern? I don't know what they call it, but.
I would honestly, I know you posed that this afternoon. I would need to ask a little bit about that as well. If they are eligible as a home education student to attend a career and technical that is not the one that we are assigned to send to, unless it's through an IEP program. Like those life
Right.
skills students, it's part of their designated IEP. The
And
IEP
Eastern
supersedes
doesn't
everything.
offer it. That's why.
Right, correct.
It's kind of like what we were talking about earlier, where it's just like the one technical school. So that's something I guess we have to
I can ask Mr. Diazio.
find out. Okay, anything else on this one? Okay. Moving on to the ERs.
Don't get too excited. We have one more, 800, records
800,
management.
Sorry.
Reviewed by our solicitor. Majority of the existing policy language is being recommended to be removed and incorporated into our AR and record retention chart. And if you look at the AR, that was revised to include a lot of the definitions and information regarding that retention. So thoughts, feelings, comments?
Anyone on this one, Jenna?
No, because I think if I followed what was moving in and out, we were really just moving things. So yeah, I don't have as much of a concern with that. I was okay with this one.
Mark?
We beat this one up like not that long ago, didn't we?
I was looking
Right?
today, I'm like, I know we had this
Yeah.
like long
Yeah,
discussion
well, I
about.
remember we talked
how to
about
delete
data,
the
right, yeah, it was the
technicals.
whole thing, yeah.
We did, and it, in my opinion, still wasn't fully fixed when we did that, but specifically around the destruction of electronic records is still an issue, in my opinion.
recall.
But I'm a little bit confused about why we're doing this at all. There was a change in like 2022 or 2023. It's covered in the PNN, explaining why it was mentioned in the PNN. There was a change to school code, but I don't see any evidence that there was. Why did we need to change it? What part of the law changed that necessitated a change for us? And then if we're doing this, why are we doing it the way we're doing it? Because what the PNN has now, there's a new policy 830 that we're not recommending here, covering separately electronic records versus paper records. And if we're gonna do it based on the changes in whatever act it was that I can't remember, then it seems like we ought to do that. And because I think we have a weakness in specifically the destruction of electronic records in our existing policy language,
Everyone says
and it
that
covers
always.
electronic records in 830, it seems like maybe we should be, although it's not really about destruction in 830, it's about retention. But
How do you know about 8:30? Did you look?
So if
because I
you-
read the PNN.
Yeah,
I'm not even on the
so-
committee and I read the PNN.
The PNN, I pulled it up, Mr. Sirotto's right, it's May of 2023, and so this is what the PNN looks like it'll say, Policy 800 Records Management. It was updated to incorporate general references for security measures and address the responsibility of individuals and service providers involved in records management. So then they give us a draft, what a new policy could look like. We sent to Mr. Diazio our existing policy, he compared the two, and as I think Ms. Evans mentioned, a lot of it was just in formatting and to make it more readable for the user and to chunk the sections. To Mr. Sirotto's point, right up above here is policy 830.1, data governance, storage, and security, and this is a new one. Ms. Kitten and I, along with Ms. Ionetti, have identified over the course of the last year which policies through the PNN need to be revised or were new policies. This month, we can't do them all in one month. So this month we chose to bring you 137 and 800. That doesn't mean that we're not saying we don't need 830. We just didn't add it to the list tonight. We will revisit that.
Then I think we should take 800 and 830 and 830.1 all together. And I would, when we do have a PNN based review and Ed has looked at them, I would really like to hear where he has identified a change in school code or state law or whatever it is, necessitated a change in our policy. Like, what is it about 800 specifically that needs changing? So that we're not just overhauling the whole thing because it seems like the thing to do, but because what is the specific change, and are we sure that our change, whatever change we're making, accommodates Act 151 of 2023?
I mean, if the committee and the board so chooses, I could go back to him and ask about 830 and 830.1, and we could bring that along with 800 back next month as a first reading and not send it to legislative this month. We can certainly do that. He did not, I'll be honest, when we sent him 800, he didn't mention anything about, oh, you need an 830. So, but I can ask him what his advice is if we need it. He did indicate to me, I have a little sticky note here, that in our AR for 800, that we really should discuss the retention of emails and add that to the chart in terms of what is the length that we're going to keep them, what is the retention, and maybe we need to include Mr. Patel in that conversation as well for what that might look like. I know that the impetus for us bringing 800 out of the list of them was we do have some very old records that are on microfiche, and our microfiche device does not work anymore. So when we get a records request from somebody who graduated in 1950 and they still want their records, we are running down to Norristown to use their machine and get them for them. Not because we don't necessarily have a policy that says we retain them. We need to get into the practice of every year annually letting people know that, you know, you graduated 6 years ago, we will be destroying your records. If you want them, please request. You have until this date. And we would really like to, if we get 800 cleaned up, start that this summer, put out public notices, let everybody know anything prior to this date will be destroyed. If you want your records, you need to request them now. Like, we really need to get into a better habit of that. We shouldn't have 1950, and I'm just picking that number. I don't know if that's accurate or not, but we need to get into a practice of adhering to the policy destruction part.
So Mark, if we move this to the legislative and then bring 8:30 next month, is that reasonable? You don't want to do 800 without 8:30, is that what you're saying?
I think it makes sense to take them all together, but there's no harm in going out for first reading and bringing it back again. Like it in terms of practice, I don't think there's a material difference there.
Just to kind of keep it moving and,
Yeah.
Okay. What does the committee think? We're okay moving 800 forward? Yep, go ahead.
Quick question though, are we actually changing anything about 800 or was it just? Yeah, because when I looked at 800, I don't see any track changes on it. So I thought it was just the AR that we were changing. Because when I'm looking at I'm looking at the version that's linked, I don't see any.
And I looked at Act 151 and I also didn't see anything that struck me as something we need to address.
Yeah.
But, Ed might see something else that I didn't see, but.
So I apologize. The wrong thing is linked in the agenda. You see the PSBA recommended version of 800. What Mr. Diazio did was take our existing 800 and he did track changes. That is under the draft portion of policies. So again, when you go up under policies and you click draft, then you can see here's the copy of records management, which is 800, and there is the track changes, the green and the pink. So his recommendation is to remove a lot of this language that is in policy into the AR. So 800 really shrinks, and a bulk of that is going into the AR.
Yeah, because when, I downloaded these from the link that was in the board update, and 800, the AR for 800 was in here, but not the policy. So I didn't actually even appreciate we were talking about making changes to 800 as a policy because the AR is the only thing that was linked. So
That is correct, and that was an oversight on Friday. I believe this week, Ms. Evans sent out an updated agenda, and if you didn't get a chance to look at it, we made sure that those were
I didn't
linked there.
appreciate that got added. That's,
So I
So
apologize for that.
for all of those reasons, I think I'm in favor of let's just
Hold on,
do them
AR.
together.
Hold on,
Right,
okay.
yeah, okay.
Rest of the committee? Yes, okay. Okay.
Can I just ask one question?
Oh, sorry. Go ahead, Jeff.
Thoroughly confused now. So the from PSBA is not the policy we'll be addressing?
So, and maybe I will ask Mr. Diazio for some additional recommendations. So he is not always inclined to take PSBA's exact version. So he actually did recommend a very different policy, and his recommendation is to put a lot of it into the AR and not into policy.
And I'm not contesting that. I just got confused as to what we're looking at. So the form of policy with all the open check boxes, we should just ignore that. That's not even going to be on the table.
That is PSBA's, and those open brackets are for the board to check mark, we want that statement or we don't, yes. So I apologize, that got confusing. The wrong one was added to the agenda. Yeah.
Okay, you win, Mark. I hope you're happy. On a technicality. Okay.
Made it to the end. I don't need it.
Oh, that's an attachment, okay.
Ms. Ionetti, would the group be willing to just quickly rattle off so that we're all in agreement which ones we're moving and which ones are staying back? I think I marked it, but I just would like to confirm. Like all the 700s are going to second reading for legislative that we agreed upon. 002 and 003 would be moving to first reading. 206 is not. That's going to come back to policy next meeting. 216 is moving to first reading at legislative. And then 907 is not moving forward. We're going to review that more. 907.1 is moving to legislative. And then all of the 137s are moving forward. We'll get some clarification on if we need to add North Montco to that. And then 800 is not moving forward. Okay, I'm seeing head shake. I just wanted to make sure because there was a lot of them tonight. Thank you.
Okay. So that brings us to public participation. If you'd like, approach the mic. You have 4 minutes, say your name and where you live.
I won't need 4 minutes. I know we're all tired. Jenny Vitella Ambler, and I will say that my 1955 was the first graduating class of Upper Dublin High School. I will have my father, who was the third graduating class, get in touch with you and get his transcript from that year. I appreciate that we are finally following a code or following a policy for the lines in the district, because even though it's only 30 some kids, it just is too loose. It's too loose. People move into a house to be in an elementary school and to be with their friends, be there like that school. All our elementary schools, our goal is that they are all equal, with all great teachers, with all the same great services, with all the same curriculum. So there shouldn't be a distinction in terms of what's better. Oh, I want to go to Thomas Fitz, or I want to go to Maple Glen, but I live in Fort Washington. One of the things that makes Upper Dublin very special, in my personal opinion, is that we are a small-based community. And one of the nice things is that my elementary kids are with each other and they're together. So to have exceptions for an entire community, or to have exceptions just because, and to have it be decided, I think, by principals now. I like that regardless of those 33 people, we can track them, you know who they are, that they can finish their years in Fort Washington or their elementary school of choice at this time. But I like that it goes to the superintendent. So it's the same person making that judgment, not one principal or one building says, okay, it's okay for you to come to our building, but it's not okay for you. It's not fair, right? So I think making those lines applies to everybody, and the exceptions go through a superintendent is a great way, and I appreciate that you're going in that direction. Thank you.
Anyone else? Okay, with that, I will close public participation. Does the administration have any response? I mean, the only thing I want to say is I don't think the principals are deciding this, correct?
Typically
Currently.
what happens is the requests all come in through the registrar, and then she looks at at the lines where they are, and she was following the past practice that she was approving those. If she needed to speak to the superintendent, she did.
Right, so there was no principals making decisions. Any other comments, questions? No? Okay, so our next meeting will follow education on, where is it? April 3rd, usually around 7, give or take. And with that,